So welcome friends on a Friday evening to another round of coffee conversations brought to you by the Emerging India Forum and Lions Club of Mumbai Shining, supported by MyTaxguru and Pravin Gandhi College of Law, Center for Corporate Laws and IPR. So what is coffee conversation? It's like having real conversation with subject experts on any industry topic and getting to know the journey of the person in an informal coffee conversation style. Today's topic is intellectual property right. Know your IP asset. Every business owns some kind of intellectual property, is it? Yes. Are you protecting your IP the way it should be protected? If not, you are having yourself vulnerable. So bad actors who won't think twice before stealing or reproducing your IP without your permission. Let us learn from the two industry experts what is an IP asset and what to do. I would now introduce our first speaker, Dr. Suman Kalani. Spotlight. Yeah, Dr. Suman Kalani is a senior faculty at Pravin Gandhi College of Law since 2006. Her areas of expertise is IPR, contract laws, property laws, and family law. She has formed at a college Center for Conflict Resolution and Center for Corporate Laws and IPR, which aims at fostering research at the said fields under the mentorship of industry experts. Dr. Suman Kalani is the author of 3 books, Banking, Insurance, and BFM. She has presented papers at national and international level and has delivered lectures at various institutions on varied topics of law. So welcome, Dr. Suman Kalani. Mansoor. Mansoor, are you there? We can't hear you, Mansoor. You're off. Mic.
Hello, am I audible now?
Yeah. Finally, we have Mansoor.
Thank you, Amir sir. Okay, our next speaker is an experienced company secretary with over 16 plus years. Yeah, 16 plus years of in the legal service industry. She's a skilled corporate law. She's skilled in corporate law, intellectual property, legal assistance, mergers, acquisitions, and a company secretarial work. She's a one strong administrative professional. We are glad to have you, CS Jasmeen Kaur, with us today. Thank you.
Yeah. So thank you both the speakers. Let's have a coffee conversation ready. Let's have a coffee ready and begin our conversations today. Over to you, Mansoor.
All right. Okay, so Sumanji and Jasmeenji, so the most common thing that we want to kick it off today is, what are the different types of intellectual property that we actually need to know about? Any of you? Yeah, go ahead. Unmute yourself.
Jasmeen ma'am, unmute. And Suman ma'am, also keep your mic on mute. One moment. 2 minutes.
Yes. Done. It's done. Yeah.
Yeah, go ahead.
Yeah, Mansoor. So your first question is, you first point is,
we want to understand what are the different types of intellectual properties.
yeah, definitely. As we all are very well aware of the trademark thing and the copyright thing. I think everybody has come across these two words in their life. And other than that, there are patent. Patent is for the invention things which are novel and which has the utility. And there are two, three things other than the trademark, copyright, and patent, which others might not be aware of. Are the geographical indications can also be registered, and the integrated circuits can also be registered. So usually we consider integrated circuit under the patent, but there is a distinctive act for integrated circuit registration also. So I would like Suman ma'am to add something to it.
Yeah. So I would just like to add to what Jasmeen said. And just to give you an example, Pringles, we all like. So let's take Pringles and understand all the IP. And Pringles, actually, I should share this story. Very interesting. The chips used to break a lot. So the company thought that, can we have something whereby the chips don't break, it stacks down, and at the same time, the same taste is there. And that's where it was earlier with Procter and Gamble. They set up this, gave the whole thing to a researcher who invented, Mr. Frederick Bohr, who did 80% of the work. And then it was given over to the other inventor, and they came up with that invention where chips are stacked up. Pringles actually was an invention. So there is a patent in that. Ab iska naam kya rakhenge? So there came the name and the big mustache, round circle on the Pringles ka dabba, which is there. So there is a trademark. Now, assuming that Pringles was made with very specialized grown potatoes in some region, then that it can also have a GI. Now, Pringles is worldwide famous and every country has an ad. So for the literary, artistic and dramatic work, we have the copyright. So we will many times in one product itself, so many kind of IPs are there. Like to show you things which are in my hand, for example, this box. I don't know whether because of the backdrop, it will not be visible.
It's okay.
But anything which is around us, our own handsets, which we are using, the phone, it is having a trademark. If I'm using, say, for example, an iPhone or anything special technology patent, the creative work, copyright, and as said, the integrated can also be there. So there are various kinds of IPs which are involved.
Okay, I think that answers our first question. Okay, now, Sumanji, one more thing on your end. So can you give us another example of what is a trademark, in simple language for our masses over here?
Why not?
Yes,
While we are driving and we are hungry, what is that first thing we look for on the streets, especially when there are kids or even we olders? If the coffee lovers would say, oh, kahi cafe coffee day hai kya? So the CC, the cafe coffee day, McDonald's. And I must share an interesting story here with everybody, how trademarks play a very important role. So trademark, I always say, is a mark on the product to identify or to distinguish with the other products. For example, Burger King and McDonald's, two different marks which are there. And usually even a 2-year-old child recognizes a product with the trademark. So if you try to show a particular famous mark, they will be able to identify. The trademark is any product, it could be any. They will always have a name so that it is distinguished with the other goods and services. So for example, currently in for example, Camlin, famous pencils which we used to use. Or for example, if we take our news media channels like CNBC, it's a trademark. Right now, the laptop which I'm using, Dell, is a trademark. So trademarks are marks which are used for any goods or any services. All the banks, Yes Bank or Axis Bank or airlines, because services, Jet Airways, even for that matter, even hospitals, anything, any goods or services can have a trademark.
All right. Okay. Do we have Jasmeen ma'am with us? Jasmeen ma'am, are you there?
Okay. We just call up. She has, I think, so not there. She'll be connecting. You
Okay,
can
not a
continue.
problem. Yeah, okay. Okay, Suman ma'am. So one more thing we want to know, how do we apply for a trademark? So say, suppose I'm a newcomer. Okay, I've just started a company of my own. How do we
Jasmine is
start it?
connected.
Okay. Oh,
Yeah, ma'am. Welcome back.
fine.
Jasmine.
Oh yeah, you have to unmute us.
Jasmine, unmute yourself.
Unmute yourself.
Yes.
Unmute.
Sorry, I think there was some network issue.
All right.
Yeah.
Don't worry.
What I missed on? Yes.
No, we were just about to start and you
Did
popped
I
in,
miss
so don't
on
worry.
something delicious on the coffee conversation? Okay,
No,
perfectly fine.
No, not. Okay.
Inputs.
All right. Okay, so Jasmine, let's start with you then. So how does one apply
Yes.
for a trademark? If say I'm a newcomer, I've just started my company. I'm like, say I'm a phone company, for example. So how do I apply for a
Okay.
trademark?
To be very honest, I'm not doing some kind of marketing for the professionals here. But honestly speaking, trademark is not as simple as we find on the Google that you can apply for the trademark online, because it involves some kind of expertise knowledge also when we do the search work, that whether our mark is similar or deceptive, because there are refusal grounds. So just to avoid these kind of complications, because once you start the business and then after 6 months or 1 year you get to know your trademark cannot actually be registered, so you all the efforts will be in vain. So putting an expertise knowledge is required. So to apply for the trademark, if the search is the first step, we look for that whether the name is on there are two grounds. So on one ground, it should not be deceptive, like it should not give wrong impression. It should not be scandalous. It should be acceptable to the society. It should not be word which is not acceptable to the society. And secondly, it should not be similar or identical with the existing marks, and which is very peculiar thing to understand. Sometimes we say, okay, one alphabet is different. So one alphabet is different or the word different can also create a problem when there's phonetically they are similar. So once a search is done, then now everything can be done online. So filing a trademark application, there's a form TMA, which we file online. Along with that, with the coming of the new rules, 2017, now if we are claiming the trademark which we are using is of prior date, even if application date is today, which is 25th of June, and you are saying your application trademark is prior date is 24th of June, so then you need to give an affidavit for the prior use evidences or proofs. And I think that also helps into the professional to provide the elaborate details, because earlier when we used to file these kind of details, department was like, what bundle of papers we are submitting or what detailed information we are submitting. So they were not very keen of reading. But now, because this has become a part of the requirement to submit the affidavit, we can include everything, past history. Like if trademark, you are using the trademark for 8 years and now you want the trademark to be registered because things are getting online, and for online working, trademark is necessary. If you're going on Amazon, if you're going on a Flipkart, so they ask trademark registration. So for the 8 years history, everything we can provide in the affidavit. Once the affidavit documents have been filed, then the department do their checking of the application, and if they find any kind of objection, so in the usual course of business, we find objection in 2 months of time or 3 months of time. I'm excluding this COVID time situation. And then if you are lucky enough to go through that situation without an objection, then trademark get advertised in the general, and that advertisement is for 4 months, which is open to the public at large to put any kind of a objection. Like if somebody think this word, I'm also using this word and my usage date is prior, so not necessary a registered trademark owner can put a objection opposition, any third person who is not even a owner of the trademark can put an opposition. And if there is opposition, then there is a whole process involved of like presentation and then hearing and everything. But if no opposition comes, then trademark in the normal course, trademark get registered in 8 months to 10 months of time.
All right. Okay.
Yeah.
Okay, that's very deep insight, ma'am. Okay, Suman ji, can you
Okay.
please like explain the difference between a copyright and a trademark?
Sure. So any literary, artistic, dramatic work is a copyright. Let's take with an example again. All the movies that we watch, literary work, and it can be copyrighted. All the songs that we hear, copyrighted. And trademark is, again, to give an example, RIN. RIN word is a trademark, but the ad which comes, irrespective of number of ads which are there, those are copyrighted. So to put it simply, what can be copyrighted, we can take it in like 6 glasses kind of a concept. Anything which is original, literary, artistic, dramatic, musical work, sound recording, or cinematographic film can be copyrighted. So when we say literary work, all the things that one can write, poems, books, it could be as small as 2 lines, 4 lines, whatever it could be. Literary, any dramatic work, even if it is a sound, even if it is a mime, without any sound, without any words, still it will be a dramatic work. Artistic work includes right from paintings to any kind of artistic work which has been published, the photographs, for example. Therefore, no photographs can be taken easily of the other person which has been clicked and used for any public thing. Any sound recording, musical work. So when we take even, for example, one song, the lyrics has one copyright. The sound which is there, the composition which is there is also having a copyright. And cinematographic film, when we say any moving image which is there, it could be like a 2-minute film. So when we go to watch movies, before the main movie starts, we always see the ads which come, but there is a certificate also which is there in the beginning. So that is a cinematographic film. Comparing it with the trademark, as I said, trademark is a mark used for distinguishing goods or services from one person of that of the other. So if we look into the market economy or the competition we permit many sellers and many buyers. For example, in the entire Corona period, if we see, like for example, the business of sanitizers, so many people came up with, but everybody gave it a different name. So that name we have, and that trademark can be a word, a symbol, a logo, a ticket, anything it could be. I mean, that is even for that matter, a combination of color. So for example, I just take my logo as purple and white and green and just a box. Because I'm taking a combination of colors, I can take it as a trademark. Even the shape of the goods, even that can be a trademark. So trademark and copyright these are the differences.
All right. Thank you so much, ma'am. Okay. Jasmeen ji, now one thing for you. I really now,
sure.
as you know, pharmaceutical industry is like a very booming industry. I think. How can you please share some insights on how the trademark law is affected over there?
Actually, I'll share some facts that Indian pharmaceutical sector is contributing as much as like 50% of the world's demand for vaccines and medicine, 50, 40%, 35%. So India is actually contributing a lot. And pharmaceutical is the industry where the trademark and patent registration are very much happening from Indian pharmaceutical companies. So they are the forerunners for trademarks. And one also fact I would like to say that in case of pharmaceutical trademark, the court is also very stringent in case there is any case for the similarity or the identical. They don't need much of the proof. The baseline is minimum proof is sufficient, because here the life-threatening possibilities are there, or it could be fatal if because of the similarity of the name of the medicines, somebody is taking the wrong medicine. So trademark registration is also very important in pharmaceutical companies. I would like to quote an example, like GlaxoSmithKline is a company which is having approximately 110,000 trademark in its name. And if we convert this value in figures, so annually they are approximately spending $2.8 million for just for the renewal of the trademarks. So Indian pharmaceutical companies are actually contributing a lot, and there is it's very much required, and normally there is a baseline for the trademark for the medicines, pharmaceutical medicine. They usually use the either the component's name or the body part name or the ailment's name as a part of the medicine. This is mostly happen. There is no fixed rule to this, but this is mostly happening.
Right. Okay,
Yeah.
Jasmeen. Thank you for that insight. Okay, so Sumanji, now on to you. So you must have heard about the big drag scenes, what took place between Pepsi and Parle Argo. So could you share some insights with that?
So,
Yeah, Pepsi and okay, sorry.
Yeah,
Yeah.
Jasmine, you
This is
can
for
take over.
Sumanji. Sorry, sir.
Okay.
No,
Take
please.
over,
Okay,
Jasmine.
Okay. Okay.
Okay, let's do
Okay,
this.
I have a
Your-
very
Yeah, go ahead.
Okay.
Yeah, ma'am. Go ahead. Yes, go ahead.
Hmm.
Yeah.
Okay. Like this case was filed by the Pepsi company, and because Pepsi company was already using the word for the bowl, and Parle has launched their fizz drink with the word this for the bowl. So Pepsi company has filed this case against the Parle Agro company in Delhi High Court, and they were fortunate to win the case for the reason they were the prior user. Definitely they were the register, it was registered in their name and they were the prior user. So they won the case, and they need to, Parle Agro had to pay a compensation also, and plus they have taken an order that all the material which is existing material, the product which is ready, even the packing products or the ready material, fizz drinks which are ready with these lines should be damaged, destroyed completely. And I think this case is still going on, and next hearing is I think in July 2021. So let's see what happens next. This is the latest I know.
Okay. Sumanji, would you like to add something to that?
Yeah, just I want to add. So, like we saw the Pepsi case, like this, if there are so many products, we use the taglines. Like, for example, LIC says, Jeevan ke saath bhi, Jeevan ke baad bhi. For example, ye Dil Mange More, etc. And this becomes like a sort of an identification with the product. And therefore, using these such taglines, though it may sound very generic, needs to be very, very careful. Like as Jasmine just shared, that, they asked to actually, I'm sure Jasmine will add more here, but we have something called as orders for search and seizure or ant-and-pillar orders, where somebody who copies the mark and uses it on their product, I can actually get an order from the court to even destroy that products which are using my mark to the last.
Okay.
Is what I'm saying. And
See,
therefore, not only the trademark, but even the taglines, one needs to be very, very careful and cautious in using. And as said, let's wait. The next date is July 16th for this case and what happens further.
Right.
All right. Okay. Okay. And so, Jasmine ji, who owns the K in the KSRTC? Is it Kerala or Karnataka?
Yeah, this is actually very tricky and very like interesting case. Who owes the K? I think we also owe the K because of this coffee. Here the K was being actually used by Kerala for the State Road Transport Corporation. It was Kerala State Road Transportation, and the Karnataka was also using the K word for Karnataka State Road Transportation. So this matter came into picture. Karnataka got registration done for the acronym KSRTC. But then when Kerala get to know, they filed a case against that because they were the prior user. And they luckily win the case also, because there's a provision in under section 34 which says even if the trademark is not registered trademark, But if a person can prove its prior date of usage, then from the date of the registered owner, in that situation, the benefit goes to the unregistered trade. So here the Kerala won the case. And I just want to add to this that to prove their case, they even used 1969 ke videos, ke visuals, movie visuals where the this acronym KSRCT was used. Sorry, KSRCT was used. So these kind of proof they actually presented in the court.
Okay.
Yeah.
So eventually, then who won it?
Kerala won. As I mentioned, Kerala won. Yes.
Okay.
Kerala won this. So now, yes, Kerala has this right for this acronym KSRTC.
Okay. Thank you,
Because
Jasmeen.
Kerala was the prior user. Yes.
Okay, Kerala was the prior user, so henceforth, they won it. They were using it before.
Even though Karnataka got the registration, but they failed because the prior user was Kerala.
Okay. All right, Jasmeen. Thank you for that. Okay, Sumanji, next question for you.
Call Gurinder.
Okay. Yeah, Sumanji, next question for you. So, what is a copyright for a normal person to understand?
For a normal person to understand?
Yeah.
Okay. Again, we split the word copy plus right. So actually, copyright, there are two important points to understand. What can be copyrighted? What is copyright? So first, let us get the point. What is copyright? I write a book. Only I have the right to make copies and sell it. Nobody else can do it. So if I write a book and we see at the signals people selling so many books and all, they don't have the rights. It's pirated. Same way, downloading a music or something doing from an unofficial website, we don't have that right. So what is copyright is my right to make copies, my right to translate it, right to adapt it, right to convert it into something is with the owner of the copyright. What can be copyrighted? What can I say that this is my copyright is again the 6 glasses or the 6 coffee cups. Original, literary, artistic, dramatic, musical, sound recording, and cinematographic film. So anything which is original and which is falling into these 6 categories can be copyrighted. Now, another thumb rule of copyright, especially when it comes to a literary work, is how long can I own it and say it's mine? To just give you an example, a very, very famous work of Harivansh Rai Bachchan. Let's take, for example, Madhushala. So when he wrote it, in whichever year, till his death, and 60 years plus. So even today, the rights of Madhushala is with the Bachchan family. Right. And same way, any other copyright work which it could be. So for instance, if I write something and I'm selling it in the market, whatever money or revenue which I get it is the right of the copyright owner. So there is who owns the copyright, what is copyright, and what can be copyrighted. That we need to see. So like, for example, some of the participants may be a very good artist and they draw something, they paint something or make a beautiful painting. It's an artistic work, sculpture, anything. So I think I would say it would go into 3 main questions. What can be copyrighted? What is copyright? And what is the duration of copyright? How long can I say it's mine? And when does it come in the public domain for everyone?
All right, so much.
Thank you. I think now software applications can also be copyrighted.
Yes. So software applications would come under the literary work, and all the 6 coffee cups which I said, original, literary, artistic, dramatic, musical work has been well completely defined in the Copyright Act also.
Right.
So thanks for pointing that, Jasmeen.
Yeah.
Okay. Thank you, Sumanji. So Jasmeen ji, one more thing for you now. So what can I protect? What can I do? What can I protect by using copyright? Like what kind of works can I protect using copyright?
See, as Sumanji well explained, I think she has already answered to this question also, that all we can protect is artistic work, whatever we are writing, any dramatic work, any drama or play we are doing, that can also be copyrighted. Any music work, songs and everything. Now we can see sometimes when we are watching the video and in between the video get muted, and then the last portion we could hear, because that song was copyrighted and the person who has added that music who has not actually taken the copyrights of that. That's why it was muted. So musical work can also be copyrighted. Then audio visual works, which is like cinematographic and the series and the serials and everything, that can also be copyright. Then sounds like Yahoo, that music, that can also be copyrighted. Then comes the software, as I mentioned, because softwares, apps we are coming out at a large extent. People are like into this online, especially in this pandemic situation, things are getting more digitalized. So I emphasize on the thing that softwares can also be copyrighted. The software is not the picture of the app, but actually coding we submit for the copyright. The animations, these cartoons and everything, animations can also be copyrighted.
All right. Thank you, Jasmine ji, for that.
Yes.
Okay. Suman ji, so
Thank you.
one more thing. Okay. Yeah. So Suman ji, if something doesn't have the copyright word written on it, can I assume that I can use it on public domain?
Can you please repeat?
I'm saying I'm okay. So if something doesn't have the word copyright written on it, can I assume and use it on public domain?
Usually we use a symbol C. Anything
Okay.
which has been published anywhere, whether the word copyright is written or not, we cannot use the other published work.
Okay.
So for example, I write a poem, I post it in the chat box here, and I put it on my Facebook or in my blog. Even if I have not written a copyright, I don't have the right, anybody doesn't have the right to take that work. So what is copyright? The right to make copy, the right to take it, that is not there. But having said that, the very important provision in the Copyright Act which permits the fair use. Certain cases, I can use the other person's copyrighted work. And one of them is like educational purpose, to write a critique. Someone wants to write a judgment. So there are a list of things in which gives me the permission. But as a general rule, I cannot make a use of the work, whether the word copyright is written or not written. If it is published, it is that person's work.
Because in some cases, what has happened, like when you see in books and quotes and everything, like words always repeat and everything. So that's a little bit confusion for me. So like someone says a particular quote and then he uses it on his or her page. So is that allowed?
So when they use, yeah. So for example, I'm writing a book and I use Mahatma Gandhi's quote or Abdul Kalam's quote. I'm giving that acknowledgement that it is not my work, it is this person's work. But I cannot take quotes and make books and then start. If it is within the copyrighted period, that is not possible.
Okay. Thank you, Sumanji, for that. Okay, Jasmine ji. So now after trademark, copyright, let's head on to patents. So what are the different types of patents we have or we should look out for?
Yeah, patent is very technical, very technical aspect. Actually, it cannot be done by the single person. It's a work of a team of people, and the patent inventor. But basic thing is that there are three type of patents. One is utility patent. In a layperson language, I'll say like machines we invent, medicines we develop new formulas for the medicines. These all are covered in the utility patent. Then second is design patents. Like we invent some kind of a bike with a particular designing, or we are making a mobile with the unique features. So these all are design patents. Then comes the plant patent. Then come the hybrid plants like hybrided seeds. That is a third type of patent. So basically patents are of three types: utility patent, design patents, and plant patents.
Okay.
And there are three basic requirements for a patent to be registered. One, it should be novel, it should be new idea. Secondly, it should have a utility. There should be some usage to it. What you are inventing, it should not be useless thing to the public at large. It should be a useful thing. And thirdly, it should not be a discovery. You are not finding out something. It should be no invention,
All right.
new invention.
Okay. All right. Thank you for that insight, Jasmeen ji. Suman ji, so having a patent in India, if I have it, can it protect me in other countries? If I have a patent in India?
Yeah. So usually we have a prior art search that we do when any patent is done. And patent, because it involves a huge R&D and a huge investment, usually there is an application which is called as a PCT application, where I can take the protection in the different countries. So that protection is there in those countries that I've taken, then automatically I will have a larger protection beyond India, which is there. Having said that, our laws are territorial, but then it gives us a mechanism to take a global protection.
All right. All right, Suman ji, thank you for that. Jasmeen ji, so who cannot apply for a grant patent?
See, who cannot, I'll say who can apply. So it's either the inventor or assistant to inventor. They can file an application either in an individual name or a joint application, or in case there was some invention and the inventor has died. So in that case, a legal heir of the deceased inventor can also apply for the patent. And what cannot be patented, I can say. So there are things which cannot be patented. Like the discoveries I said, if you are digging something and you find out something from the history, that cannot be patented, because that belongs to the society at large. So rule of nature cannot be patented. Gravity, theory of gravity, or air, these kind of things cannot be patented. And the abstract ideas like mathematical calculations or scientific theories, these are the things which you cannot patent. So generally, patent can be, as I said earlier also, something which is useful to the society and which is new, which is an invention, should not be a discovery.
So could you give us a case study or something on a patent?
Like as I given you an example, like if you go for a patent on some mathematical formula, you are saying that this formula can be used to calculate the velocity or something which can be helpful in the architecture work. So you cannot get the patent for that, because that trade, as I said, patent is a very technical thing. But if using that formula you have produced some equipment, and that equipment can be used in a particular way which could be used by the architect, and that will help him in his work doing in a better way or is an easy way, so that equipment can be patented. But that formula, only mathematical formula, that or a scientific theory, that cannot be patented.
Okay. All right. Thank you, Jasmeen ji. Okay, Suman ji, this is I really am dying to ask you this one. So what kind of research work does an IPR expert have to do? And I really would want Jasmeen ji also to answer this after Suman ji. So go ahead.
What kind of research work?
Yeah.
Yeah. I think if I can put it into two ways. As a practicing lawyer, what kind of a research work probably one may have to do it all the time? As an academician, what kind of a research would go? So I would say, the fact that I have to file for something, whether it's a trademark, patent, or copyright, I need to know whether it's existing or not. And also need to know whether this thing can be trademarked or can be patented or can be copyrighted. The best way to know these things is also through the decided cases. So I would say whether academician or researcher needs to be very updated with the contemporary happenings worldwide also. So though our laws are okay, I know that trademark law will be applicable to India, but for instance, now everything is happening online. So initially, a domain name, for example, any domain name, for example, let's take makemytrip.com. it would not have got a IP protection, a trademark protection. But now after judgments, after looking into these some other jurisprudences and other judgments, now we say that, okay, even a domain name can also seek a trademark protection. So when we talk of the research, we need to know the local, regional, national levels, what are our laws. At the same time, one needs to keep updated with the international happenings and definitely the court judgments, because that also eventually determines a lot at the end, that what kind of work can come within the framework of the IP.
Right.
So this
Thank
is
you,
from my
Jasmine.
side.
Yeah, Jasmine ji, you can add into
I'll
that.
just simply one or two lines just want to add, like intellectual property, as the word say, it's an intellectual property, mind property. So it's a creation of mind. So if your mind has created something, then you need to protect it, whether it's a written work or whether it's a form of medicines or whether it's designing or brand or logo. So here I would like to ask ma'am, Suman ma'am has well said about the domain name, which can also be traded. Now I'll just quote an illustration example. Armani, we all know, is a brand for the
Yes.
aprils and the bags and all, a high-ended brand. So there was a person in India, in South, I exactly know the place name, whose birth name on the birth certificate was Anand Ramnath Mani. So he took the word A, Anand ka A, R from the Ramnath, and Mani, Mani was his surname, and he created a website, armani.com. And he was doing the architectural work. Where when Armani, that high-ended brand, get to know about this website, they filed a case against that person in a WIPO. And what WIPO has decided was very interesting, because WIPO said, because his birth certificate is also having a name, so he is using his name initials and the surname only, so they allowed that person. And Armani actually lost the case, and that person was not so keen to continue with that Armani name, because his work, architecture work, can go with some other also. So he proposed to the Armani company to pay him $2 crore million.
Okay.
And the company agreed. And actually, he got, just because of his initials and his surname, he got $2 crore million. So we can actually understand how important our creative mind is and how important it is. So if Armani has got their domain name registered before only, so they could have saved themselves from paying this much amount. So it's our creation. We should protect. We should protect so that others cannot misuse it.
Fair enough. All right. Okay, over to you, Amir.
Yeah, thank you, Suman and Jasmine. So
Yeah, thank
this
you,
is an interesting
Virani.
one which we have completed. A lot of insights have been shared. Let us answer participants through a Q&A, through a poll. Okay, what was their understanding of the topic? So I'll just open. Subhash, you'll have to do it.
Yeah, friends. I'm sorry, from my machine, I can't see the poll. So I've come on another machine. So yeah, you got 5 seconds more. We have got a response of business name, different types of IP assets. Okay. So let's end this. Show results. So we got for business name 5%, label 5%, logo 16%. That's good. So both of you have given good insights so people could answer. So let's go to the next one. Yeah. Sorry. So we have one moment, because this is relaunch. Okay. And calling. Yeah, friends, we have this. You have got 10 seconds. Wow. Thank you. Let us see the results. Oh, wow. 67% answered 10 years. So that's the correct answer. Thank you. Oh, sorry. Yeah. Validity of trademark, friends. Yeah. 10 seconds. Thank you. 84%. So, validity of copyright. Ten seconds. Okay, thank you. Wow, 82%. That is the correct answer. Life of the owner plus 60 years. So last question of the day, validity of patent in progress. Sorry, validity of patent. 10 seconds. Wow. So correct. 70% said 20 years. That is good. So now, this is the end of the session. Any queries, people, friends you have, you can ask questions before we go to the next round.
Sir, I had a query. Can I ask?
Sure. Come on, ये camera. Who's it?
Hi.
Harsh, sir.
Yeah, can you come on camera? Harsh को camera पे लो, spotlight में लो. Yeah. Thank you, Harsh. What's your query? Shoot.
So, sir, as Jasmeen ma'am had told, so for the trademark, we have to take a symbol which is acceptable to the society. But how do we define what is acceptable to the society? For me, a piece of cigarette would be acceptable, but for the society, the same piece of cigarette would be something which is not acceptable.
Can I answer to this?
Yeah. Go
Yeah.
ahead, ma'am.
Sure, go ahead.
So anything which is scandalous, just like anything which can create a scandal in the society, is not acceptable to the society. Anything which is you are disrespecting any religion, Here I would say using any religion name and using it with the cafe or the pub. So that is also not acceptable to the society. So considering these things, and if you are using a cigarette image for some kind of forum or for a cigarette packet only, I think it'll be acceptable. But using a cigarette for any food items or for anything which is related to children, I think that will not be acceptable.
Your
So
share screen.
decision is actually with the,
Listen, ma'am, one moment.
sorry.
One
Yeah, yeah.
person is sharing
Yes.
the screen.
Okay.
Stop your screen sharing, friends, and keep your mic on mute. Respect the speakers who are giving valuable advice. Yeah, go ahead, Jasmine.
Yeah, sure. So anything which is misleading can also not be acceptable. Like if you're saying, "Okay, this is Kashmiri apples," whereas it is just another apples you are selling, taking from the market, and you are using the brand name Kashmiri. So these all things are, you are deceiving the customer. So where the your consumer is being deceived. So as you have said, cigarette you want to use as an image which is acceptable to you, but it will not be acceptable to society for the food item, will not be acceptable for the children items. But you might use this cigarette image if you are creating a trademark for a club or a bar or something like this. So I think I've tried to make it clear. So where what can be used is a thing to be decided. That's why where I use mentioned in earlier also, the expertise knowledge is required for this. Who can do better? What can actually be used rightly and what can be acceptable by the department, where you can get a benefit from that registration.
Okay,
Like to
ma'am.
just
Thank you
add
very
to
much.
what Jasmine said, Harsh, like certain slang words which people use, it may not be acceptable normally to get a trademark for that. So there were cases on these earlier. Okay, even if I make a slight modification, but if it is going to be visually appearing that it is a word which is not acceptable in a normal communication, it will be rejected. So something which is immoral, opposed to the public policy, something which the Names and Emblems Act allow. I cannot take India ka flag and say that this is, I like and I'm patriotic, so I want to take India's flag as my trademark, or any leader's name. That will not be permitted. Okay?
Yeah, ma'am, Suman ma'am. So I had like a corresponding question to that.
Harsh,
Yeah.
overshooted our time and we have got one more round.
Okay. Sorry, sir.
Yeah, take up your question in the end. Sorry, friends, we have kept the session for 1 hour, but so many interesting things are coming up. We will be continuing this. This will be an ongoing series. So let's come to keep your questions. We'll be taking in the last if the time permits, or you can send us the question. We'll have it answered later because this is an ongoing series on IPR. IPR is very huge topic, and there is different sections which will be coming up. Now, let's come up. We have known the subject. We did a Q&A. Let us know, because this is a coffee conversation. We should know who is Dr. Suman Kalani and who is CS Jasmeen Kaur. You want to know? Just put in the chat. Put in the chat, yes. So we can start on that round. Wow. Thank you, Vinayak. Thank you, Rashmi. So let's start. So over to Jasmine.
Yeah, please.
Yeah. First question will be, you are a CS. What prompted you to add one more title to become a IPR expert, a trademark agent?
Yeah, I would love to answer to this question because I never planned going into this IPR field, but this just came through, like I was doing my CS work and my clients came up with for the filing of trademark application. So because so much work was coming, so I started reading about it. And before I could do actually professional, then I did my IPR diploma also. But before doing my IPR diploma, I filed 5 to 6 trademark applications just by reading from Google and from the books. I thought if I'm getting the work, why not I take a professional knowledge and I become an expertise in this so that I can guide my clients in a better way. So it just happened to me, and I'm more than happy that I did it, because this is so upcoming thing at present. I would like to mention that everybody is so keen for the protection of their marks now. So trademark is so much in, like, every second, third day, somebody calls you for an opinion on the trademark or for the work. So it's so upcoming and thing in the market.
Thank you, Jasmeen. Continuing with our questions, what kind of life is an IPR expert is?
Yeah, it's interesting because especially I think I enjoy the work of search. But when I'm doing the search for their word, so many a times we also need to apply our mind, the creative mind, because doing CS, so we are so into these legal things that create, sometimes we lose the creativity. So when I'm doing the search work for my clients, so sometimes they ask you, okay, if this word is not acceptable, then you suggest what variations can be acceptable. So then we try to find out the new words or new ideas or new images and pictures or combinations which can be used to get the registration. So that is the most interesting part. Other things are more technical, which I think, as we have discussed in the seminar, this coffee conversation also. So this creative thing is the most interesting thing.
Thank you, Jasmine. Next question, continuing. Difficulty you faced in your IPR journey, what steps and how did you overcome them?
The most difficult part initially I used to come across was the objections, because in 90% of the cases the department was sending the objection. So I was like, whether there's some problem with my application or it is the ritual, it's the practice by the department. But then somehow, as I mentioned, like in 2017, when this amendment came and we need to file this affidavit of the prior use, was so advantageous to us in a way that now when we are filing this affidavit, we make it so detailed that we try to not to leave any stone unturned and file the affidavit in a way with indication that there's no such possibility of objection. So I think overcome with the amendment in the rules only. And that was the most scary part for me for the next 6 months, because before this become online, the time period the department used to take was a longer period. So for 6 months, I was like, after third month, I'm gonna get the mail for the objection. I'm gonna get the mail for the objection. So I used to keep my fingers crossed. So now it's a better, like in affidavit, we are getting all detailed information that company has a goodwill, company's turnover is this much, and this is the promotional expenses company is making and whatnot, everything.
Thank you, Jasmine. Last question for you. Have you dealt with a customer who's not so keen to go for IP protection? And what did you do?
Not so
Get him on-
keen.
Yeah.
See, because we don't pursue the people for the registration. People come to us for the work. So I actually didn't come across, other than my own family members, maybe I push them to get the registration done. So I have never come across anybody who's not keen. So the most interesting thing is, from a chole bhatura person to a 20 crore turnover corporate is my client. So I think everybody is interested nowadays.
True. Everyone has to protect the IP assets. That is
Absolutely. They should. They should.
Thank you, Jasmine. Over to you, Suman. What made you go in teaching?
Sorry?
What made you become a professor?
My passion.
Career as a
My passion for teaching, I would say. And once I joined teaching, I think I was learning more. And the quest to learn more made me continue in my teaching. So where I joined as a visiting, I now became a full-time. So I came from the practice domain and then moved into teaching and saw both the worlds. So yes, my passion for teaching, my quest for learning, Every classroom has been a wonderful learning ground for me. The young minds every year has been different, and that keeps my enthusiasm and energy level all-time high.
Okay, that's interesting. So where were you earlier before you came into teaching?
I was working as a practicing lawyer in Mumbai High Court.
That's interesting. So how has the journey been, Sumanji, with the students?
That's what I said. It's been amazing. My 15 years in the legal education, I think every year has been equally exciting. Same subjects, different questions, different perspectives, different dimension. So I never feel that I'm teaching the same subject, because there has been so much more to learn every time. Also, very interesting part about law is evolving. The society is changing, and therefore I think teaching law has been exciting and challenging always. With students, I mean, it's amazing always to see their journey once they pass. It's been like your own balance sheet that we see, wow, that someone has reached at this position or someone is doing this. I think that is really rewarding. So I think teaching will always be my passion for that reason.
Okay.
And
Yeah,
Sumanji, your passion was very clear as you explained the thing so nicely. I think everybody could have understood easily. It was so easy to understand
So
what you
true.
were saying now. Yeah,
We're very fortunate to have both of you.
thank you.
So next question will be to both of you. It's a common question. What are the opportunities for students as an IP expert? And Jasmine, over to you. Okay. What are the opportunities, growth opportunities for an IP expert? So someone
Definitely, lot of, yeah. Yeah, there's a lot of opportunities, like in the patent field, in the trademark field, in the copyright field, particularly for the software application thing, for the geographical indications everywhere, not only at the national level, but at the international level also. People are getting more aware of their creative thing, their brand image, and they want to protect it not only in this global world. They want to protect it not only in the country of origin, but internationally. So it has a lot of scope. So if anybody is thinking to pursue this profession, must go ahead. If you have an interest, there's a lot of scope in this field.
Okay, thank you very much. Sumanji.
Yeah.
I would like to just add, I feel it's like adding the opportunities every year have been adding. I was just thinking during the lockdown period, suddenly so many people became more creative. We could see so much of more literary work, more things which came up. Also, like if we take on the other hand, the Make in India initiative, right? They want us to do so everywhere IP will be required. And therefore to see the opportunities where it comes, I would say not only for law students, but even for other people, there are opportunities in the field of IP, but specifically talking for the law students, the opportunities would be in the corporate sector, in the I can say practicing, that is the litigation and non-litigation. So in the corporate sector, for example, if I'm a IP manager or IP team leader in, let's say, Hindustan Unilever, who has more than 2,000 brands, and every day there are cases. So I may handle their department and their IP related issues. In the practicing side, litigating lawyer, filing and fighting cases of infringement. And what is a non-lit practice would be, a lot of IP gives an opportunities for revenue generation. And this revenue generation happens by licensing of an IP. So if I have a patent or I have a trademark or I have a copyright, I can allow the other person to use it. And that allowing the other person to use it would be by way of the licenses. Other way is I can sell my IP. So in those situations, the agreements which are drafted, that has a lot of scope for the this. The other thing is a lot of startup guidance that we do also needs a guidance of the IP to the particular entrepreneur. So I think immense opportunities are there. are just that few which we have listed out. More will keep coming, I'm sure about it. Like to just example, the OTT platforms which came up. So the kind of agreements which came with the distributors or with the producers differed. So now where earlier there was a distribution agreement with the theaters, now how these OTT platforms, Netflix and all will work. So I think everywhere IP is required.
Very true, very true. So last question of the day, which is common to both of you. IP field is evolving every day. How does one keep abreast of changes related to IPR? Should I repeat again? IP field is evolving every day. How does one keep abreast of changes related to IPR?
I think just keeping yourself aware of all the cases coming up, because every case come up with a new theory. So you're getting a new knowledge. Like as we talked about this PepsiCo and Parle-G, that if a tagline of a PepsiCo was being used by the this Parle-G, or the case of this Kerala and Karnataka K. Am I?
Yeah.
You're audible, ma'am.
Yeah. Should I continue?
Yes.
Yeah. Okay. Like this case. So all these, keeping yourself aware of all the cases coming up, and then reading more articles.
And to add to what I think Jasmine's screen is free.
Screen is free.
So I'll continue to add to what Jasmine said. Just keep updated, and the best way to be updated with the IP disputes is the newspapers. And there are very, very good IP portals which are there, like Spicy IP, Banana IP. And I think one should regularly keep reading, or at least going through that what is happening.
That's interesting. We'll just wait for Jasmine to come in because we have to take group picture. Yeah, I think so. She has joined in, or so. Meanwhile, what we do is Mansoor, she let her join in, and we can propose a vote of thanks. Go on, invite.
Yeah. Let Jasmine enter, and then I'll propose the vote of thanks.
She's joining in. Yeah, I think so. She's joining in. Yeah, thank you, Jasmine, ma'am.
Oh, you're back.
Yeah, welcome back. We are just at the end of the session. So what we'll do is, let's take a group pic. Everyone on one screen with a smiling face, with a coffee cup in your hand, and let's go ahead. Everyone, Virani, Elisha, Rashmi, Raghav, Rohit, Harshan, Sakina, Chauhan sir, Hiral, Rishikesh. Everyone, please put your pictures on. We'll take only 2 minutes to take a group picture. We are waiting, friends. Subha, done? Yes. Solid, Subhash. Perfect. Yeah. Thank you. Done. Mansoor, over to you.
Thank you.
Right. All right. I would like to now invite our community manager, Samantha, to propose the vote of thanks. Samantha.
Hello. Mansoor?
We can hear you. You can go on.
Yeah. So thank you so much, and it was, I think, a wonderful opportunity to collaborate and to take up these series, and I'm sure many more to come.
Yeah, sure. Yeah, we are just waiting. Samantha, are you there?
Samantha.
Yes. Can
Please
you
go
hear
ahead.
me?
Yeah.
Yeah, you're audible.
Yes.
Go ahead.
Good evening, everyone. Actually, on behalf of the Emerging India Forum and the Lions Club of Mumbai Shining, I would like to actually thank our esteemed speakers, Dr. Suman Kalani and CS Jasmeen Kaur. And
Thank you.
Your mic, Samantha.
Your mic's muted.
Samantha.
I think important words came.
hello.
So,
Samantha,
I'm
Yes,
so
continue.
Samantha.
sorry. Yes, actually, I'm so sorry about that. I was just saying that actually this conversation was so insightful and the examples were so simple and realistic. So it actually made it very easy to understand the concept and the importance of IP assets. And also, I would like to thank our community partner, which is the Pravin Gandhi College of Law and the Center for Corporate and IPR, and also our supporting partners, which are MyTaxguru and the Advantage Learning. And if you go to see that this is just a part of the series, as our sir said. So if you go to look, like we have many other series coming up, and we would like you to actually attend our programs at the Emerging India Forum, the coffee conversations, and also the other events which are happening. So we would like to share our social media handles actually on the chat, and do follow us, guys. And also, lastly, I would like to thank our amazing audience who actually removed time from their hectic schedules, okay? And you actually made time for this event. So thank you, everyone. And yes, do stay safe due to Corona. There's a lot of things happening. So do stay safe, keep learning, and yeah, enjoy your weekend, guys. Thank you.
So thank you.
thank you, Samantha.
Thank you,
Thank you
Jasmine.
so much, Mr. Virani.
Thank you.
Thank you, Mansoor, and special thanks to Sumanji. And thanks, guys, for providing this platform. It was a great opportunity. Means a lot.
The students of Pravin Gandhi College who did a wonderful job of working together, and yeah, we will be working on many other things which will be coming up, or different series, different types of learning sessions, coffee conversations. Jasmine, you will be an integral part of a coffee conversation of the Emerging India Forum. You too.
Thank
It was
you.
a lovely conversation which we had, different
Mhm.
format from a panel discussion. I hope both of you enjoyed this format, and do share a word on LinkedIn, on Instagram, so people come to know about this coffee conversation, which is a different type of coffee conversation. You're learning about the topic from the subject expert, plus also knowing about the person, the subject expert, which is very rare concept, which is there prevailing. So we need your support. Thank you. Stay safe.
Thank you all.
Thank you. And applause to the team. Thank you.
Thank you. Bye.
Thank you, guys. Bye.
Bye-bye.